if you're making the decision between a fiancé visa and a marriage green card, there are a lot of different factors you have to consider. We go over 10 different reasons and things you have to think about before making a decision of which is better for you, a K-1 fiancé visa or a marriage green card. I'm immigration lawyer John Kasravi. I help families just like yourself come and live their lives in America. Now, the detailed guide about the process, if you go to marriageimmigrationlaw.com, you can download the Ultimate Marriage Green Card Guide, John's Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com for free, 40 plus pages that will get you to where you need to be before even talking with a lawyer. But let's get started. The first thing we're going to talk about is what is a fiancé visa versus a marriage green card. In this context, you have to be a U.S. citizen petitioning for a foreign fiancé or citizen. Fiancé visas are only for U.S. citizens. The fiancé process means you're not married, but you've seen each other once in the last 2 years, and you're going to apply for the foreign fiancé to come here to get married and apply for a green card. Whereas a marriage green card, you're already married, and you're going to go through the process to get a green card for an existing spouse. With that said, let's go to issue number 1, processing complexity. If you're doing a fiancé visa or a marriage green card case, you initially have to notify the U.S. Immigration Department, USCIS, that you're interested in this process and that you have this relationship with a foreign person. If doing a fiancé visa, you submit Form I-129F. If you're doing a marriage case, you submit Form I-130. Once that's done and approved, the next step is dealing with the U.S. Embassy abroad, getting an interview, submitting documents, and getting a visa approved so you could enter the United States. The fiancé visa gets a non-immigrant visa called the K-1 at that time. In marriage cases, either get what's called a CR-1 or an IR-1. We'll go more in detail into that in another part of this video. But those. You go to the embassy, you get the visa, you enter. The difference is here. If you're married, you're done. But if you're doing a fiancé visa, you still have to get married in the United States within 90 days and then apply for adjustment of status from I-485 along with some other documents. So if you're married, the case is done and complete. If it's a fiancé visa, you're only halfway done. There's more things left to do. So that's an important thing to consider when you're doing this case. The second thing we're going to talk about is the timetables. Now, one thing to note is timetables change all the time. So anything I say here can go up and down. But as of the recording of this in late 2023, the first step of the process, going back to what we talked about earlier, for a marriage or green card case, have separated pretty tremendously. A few years ago, both were taking around 6 months. But right now, the Form I-129F for the first step of the process with USCIS is taking around 18 months, a year and a half for fiancé petitions. But for marriage petitions, Form I-130, they're taking around 12 or 13 months. USCIS had said by this month, where I'm recording this, October 23, that they're going to bring all the processing times down to 6 months. But the opposite has happened. They're doubling, almost tripling in some cases. But it gets worse. Once the first step is approved and you move to the embassy step, historically, fiancé visa interviewees would get their interview faster. Applicants, the foreign fiancé, would get their interview much faster, maybe 1 to 3 months after USCIS approved the initial petition, whereas marriage cases would take 3, 5, 6 months to get an interview because the marriage cases will turn to green cards. They do a lot more work into the case on the government side, whereas fiancé visas are not completed because you have to come to the United States to complete the process. They happen a little faster. But with COVID and other kinds of delays, getting a fiancé visa appointment in some embassies is taking just as long as a marriage green card case. And each embassy does it differently. For example, Pakistan might take 2 or 3 years, whereas somewhere like in London, it can take a month to get an interview. It's all over the place, so be aware of that. But when it comes to these timelines, the initial petition on a fiancé visa is much longer, and getting the embassy appointment to get an interview and a visa is taking on average the same amount of time. So there's no time saving there by doing the fiancé visa, along with the fact that if you're married, once you come to the United States, you're done. But the fiancé visa, once you come back in, you got to wait to complete the process and sometimes even do an interview. So it adds the time to actually get the green card. So it might take some extra amount of time or more to enter the United States as a fiancé, but you're not done to get the actual green card. After entering, there's still more work to be done. Number 3 are the costs associated with this process. As I mentioned, the fiancé visa process, there's more steps to it. We're not going to talk about the attorney fees involved. We're going to focus solely on government fees. But for both types of cases, the initial step right now costs $535. Once you move on to the embassy step, if you're doing a fiancé visa, there's $265 visa fee. For a marriage case, you start $445, and once approved, $220. So the marriage case in total will cost around $1,200 in government fees. However, the fiancé visa, once you enter, you have to file for adjustment of status from I-45, spend an additional $1,225, bringing the total almost $1,000 more, $800 more, that's $2,025. But there's also costs associated with medical checkup, vaccines, translations, police certificates, and things like those that I didn't include because they're not pure government fees. And there's fees that you should be aware of. Number 4 is work authorization. When you're doing a fiancé visa and you enter the United States, you're not allowed to work. You need to apply for a work permit, and that's going to take many, many months. Whereas if you were married and you came in, you essentially could start working immediately once you enter the United States and your immigrant visa is stamped. Now, you got to get your social security number, but that should happen rather quickly in most cases. But just having that stamped visa in your passport will be enough permission for you to work. So that aspect of getting your life started much faster in the U.S. becomes very important, whereas with a K-1 fiancé visa, you just got to wait until you're legally allowed to work. Number 5 is travel permission, which is very similar to the work authorization. If you enter with a marriage green card, immigrant visa to get a marriage green card, you're in and you're done. You can come and go as you please. You can't be outside for too long, but you're able to travel. Whereas on a fiancé visa, once you're here, you got to stay here until a green card is issued, or you apply for a thing called advanced parole travel permission from I-131 to permit your travel while the case is pending. But that takes so long, you might just get your green card approved anyways. So there's an aspect of a fiancé being stuck in the United States. If there's an emergency back home, they need to travel to visit a relative or some financial issue happens, they have to get expedited emergency permission to travel, which adds to costs, delays, headaches, and all that kind of stuff. So it's another factor to take into consideration in your life when you're going to get married or get engaged and what process you're going to pursue. Number 6 is about removal of conditions from I-751. As the rules are, to make sure that the relationship was not fake and it was a real marriage, for people that get their green card issued, printed within 2 years of their marriage date. So imagine you get married, you go through the process, you get the green card. If the green card is issued less than 2 years after marriage, they'll give you a conditional green card. If the green card is issued after 2 years of marriage, you'll get a 10-year permanent green card. The conditional green card means that once you get the green card, it's valid for 2 years. Near the expiration of that 2-year green card, you have to file another application from I-751 to tell the government and show the government again that you're really a couple and that you're married and doing all that kind of stuff. More cost, more paperwork, and more headache. Now, if you do a marriage case and the case gets done fast enough, you may be subject to this as well. Half the time you are. But with the K-1 fiancé visa, every time you are, because almost every time the green card is going to be issued within 2 years of the marriage, because you get married in the U.S. and at the end of the process, whereas for a marriage green card case, you get married before even starting the process. So the likelihood of having to undergo I-751 removal conditions increases, which means more interactions with the government. Number 7 is applying for citizenship. If you've been living and married and living with a U.S. citizen after getting a green card, you can file for citizenship 3 years or even 90 days before the 3-year mark if you satisfy all of the other requirements. If you're married and you get your green card like that, you enter the United States, you immediately start counting the citizenship clock. Whereas if you came on a fiancé visa, the time you spent living together until the green card is approved is not counted towards the citizenship time period. So it'll speed up getting citizenship quite dramatically, maybe 6 months to a year many times. So that's something to be mindful of. Number 8 is how streamlined the process is. When you're doing a marriage green card, there is a more formality that you have to deal with the National Visa Center, how the document collection happens, and how the embassy processes these kind of green cards. It's been pretty standardized. Unfortunately, for the fiancé visa process, almost every embassy has their own procedures, how they want the documents to be broken down, how they schedule interviews, how they do rescheduling, how they register the event, all this kind of stuff. Every embassy essentially does it differently. So every time we're doing a fiancé visa, we're kind of reinventing the wheel to see how that particular embassy wants to deal with the issue. So these are the complexities that come and increased costs. You have all these extra steps for a K-1 fiancé visa, more government fees, more attorney fees, and the complexity that you deal with trying to figure out how this embassy today is dealing with it as opposed to how they were doing it 6 months ago requires more time, more analysis, more pushback from them. So it increases costs and headache. And similar to that, number 9, K-1 visa, the fiancé visa, is a non-immigrant visa, which means you're coming for temporary purposes. It categorizes that as that because it's a one-way visa. And for example, if you come and you don't get married, you have to leave. You can't stay longer. So that's why they consider it a non-immigrant visa, technically in the name only. However, because you are going to get married and you get a green card most of the time, in practice, they deal with it as an immigrant visa, which is kind of confusing. But there's pluses and minuses that come with that. But it's a weird situation which causes confusion because many times they'll put laws out that say, K1s or non-immigrants can do this, but they'll treat the K1, which is an immigrant visa, as a non-immigrant visa in that category, or sometimes they'll treat the immigrant visa. I'm sounding kind of confused because it is confusing because they'll deal with it randomly. Sometimes they'll consider a K1 visa, although nominally a non-immigrant visa, as an immigrant visa. A person's coming permanently, like a marriage agreement case. Sometimes they don't, which leads to number 10, how they deal with these things differently, which is actually an example of that. For example, when the pandemic happened, there was a ban on people who were not, who haven't got a shot or couldn't come to the United States because of the pandemic and all that kind of stuff. They made an exception for people who are spouses of U.S. citizens. Now you think, okay, fiancés are going to be spouses too, let's do the same. But they did it differently. So all of a sudden, fiancés who thought they were going to come faster than marriage cases got stuck outside because they weren't part of the exception for entering the United States where spouses were. So you see how they treat this differently, but in other contexts, they'll treat it like an immigrant visa. So it's a confused matter. And these are all different factors you have to consider when you're making a decision to do a K1 visa. Now, if you've been listening to this whole thing, you'll probably think and understand, like, I'm not inclined to do fiancé visas in probably 9 out of 10 cases, if not 99 out of 100 cases. Very rare times where a fiancé visa would be appropriate. For example, we had a case where a woman was asylee in the United States. They couldn't go back to her home country, but her fiancé was there, and her mom was in the U.S. as well. She said, I want my mom to be at our wedding, so I don't want to go and get married and then file for the case because I want my mom to be at the wedding. Well, 2 years later, and headaches, she deeply regretted it and said, I just wish we got married and got this over with. This lovely angle of having my mom at the wedding wasn't as big a deal as being separated and all the extra costs that are associated with it. Another case example we used to have was for same-sex couples who couldn't get married in most countries. They're forced to do the fiancé visa. But nowadays, because you're allowed to do video marriages and then afterwards see each other to lock in the marriage in the eyes of the government, there's no point to do that either. So traditionally, a typical time I'll recommend a fiancé visa nowadays is also for people who have barely any relationship history. They just met. So it's more appropriate that they come to the U.S., spend 90 days together, then get married to see if they actually want to be together, not jump into it. But if someone has some history of relationship that they develop and have evidence of that development, communication, seeing each other, all that kind of stuff, almost always the marriage case is going to be better than the fiancé case. But it depends on your case. So I recommend schedule a consultation after you download our guide at marriageimmigrationlaw.com, the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. Review that, get some basic understanding, and then schedule a consultation with us so you can ask really pointed questions, not the basic ones, really next level questions about what the process entails for your unique fact pattern. I'm immigration attorney John Khosravi. I love helping fiancés and married couples get past the finish line and live their lives in the United States and start families. It brings a lot of joy to me. And I hope I can help you through the process and be with you through it and to a joyous end.